Assault by contact? Assault by threat? I'm Jeff Hampton with the Hampton Law Firm. Today I want to talk to you about the subject, have you been charged with assault by contact or an assault by threat? Is it possible to be able to get those charges dismissed? By the way, if you wait around to the end of this video, I'll also provide you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Now, let's talk about this for a few minutes. This is an area that many people have a hard time even imagining that could happen. You mean to tell me that I can be charged with an assault and all that happened was a threat that took place or a so-called threat? Or wait a minute, you mean I can be potentially charged with an assault even though no one was hurt? And that's exactly what it is, because when most people imagine an assault, they think of one person hurting another person. According to the law, however, there is a nuance to that where it's not necessarily required to have an injury in order to be charged with an assault. In fact, it's possible you don't even have to touch someone in order to have an assault charge brought up against you. Now, I'm going to first talk about two different types of assault. One is assault by threat, and then we're going to talk about assault by contact. Okay? Now, an assault by threat occurs when someone intentionally or knowingly threatens another with imminent bodily injury, and it can be serious bodily injury or death. And one of the ways that people do that is to say, you know, they come right out and maybe they make the mark that they're going to do this across their neck, and that person truly fears. They are truly in fear for their life. They really believe that what that threat was, or that implied threat, was that they were about to be killed or be seriously injured. Okay, so does that seem a little broad to you when you hear that? I mean, how many times have people said things either in jest or maybe said things where you never really know for sure if they meant to do it? You got to be careful, because you could technically be charged with an assault for someone who just said, I'm going to kill you. Now, I'm not saying someone should ever say that, but I'm just saying what I've seen people do that as a prank. I think back in college, people that have done that and created it as a prank. Well, even if you were really scared, you got to be careful. You can actually someone can end up being charged with an actual crime of assault. So there is good news, however. There's a lot that goes into proving an assault by threat. And we want to dive into the way these types of cases work. So we have assault by threat, and then we have something called assault by contact. Okay. Now, an assault by contact, basically what that is, it is a ticket. It's a Class C citation, a Class C misdemeanor. There you're talking about intentionally or knowingly contacting someone, and it's offensive. Not even an injury. No injury. They're offended. Okay, now how subjective is that? You know, let's say someone bumps into someone else at the grocery store and they feel like somebody was doing that intentionally and they were offended by that. I mean, legally, technically, if the officer shows up and they call the police, that person could end up potentially being cited for assault by contact, this offensive contact. Now, unless the alleged victim is a protected category, like someone who is elderly, disabled, pregnant, or something along those lines, an assault by contact is going to be charged as a Class C misdemeanor. Now, what that means is that the maximum penalty is a $500 fine. You cannot go to jail for it. Now, the temptation is this. I'll have people call me all the time and say, well, if it's just a Class C ticket, it's not any different than a, speeding ticket. So why should I care about this? I'll just move on with my life. Be careful, that would be a mistake. Because if you choose to walk into a courtroom, because here's what will happen. Let's say you're charged with that type of crime. You go to court on your own. That prosecutor is more than likely going to give you two options: pay the fine or go to trial. Okay. Now, I want you to understand, on an assault by contact citation, if you pay the fine, you are convicted. It is a plea of guilty, and it is permanently on your criminal record. All right. Now, if you go to trial, the prosecutor's not afraid of going to trial against you as you represent yourself. They feel like they'll just be able to call in who they need, and they'll take the case to trial. Now, if you hire an attorney, there is an opportunity for you to be able to do something where you can negotiate your case for a way to potentially be able to get the case dismissed and expunged from your criminal record. Okay. Now, see, here's the thing. Some people say, well, so what? I wasn't arrested, so why does it even matter? If I pay the fine, or even if I'm found guilty, as long as it's not an arrest record. Here's the problem. Recently, under Texas law, all of the local municipalities are requiring every single assault by contact, if there's domestic violence related to it in any way at all, they're requiring each individual to have to be fingerprinted and to be inputted into a database. So it's very important to be careful, especially if it's involving, a girlfriend, a boyfriend, a family member, somebody that's in a dating relationship or something along those lines. You can really jeopardize your future if you walk in and pay that citation. Okay, so one of the most important terms in the definition that we talked about here is talking about imminent bodily injury. So under the Texas Penal Code, when we talk about challenging an assault, I'm going to talk for a minute and pivot to talking about an assault by threat charge. What is actually imminent, right? Well, let's look at what bodily injury means. Bodily injury under the Texas Penal Code means physical pain, illness, or any impairment of physical condition. So literally, that means ouch, right? That hurt. That's what that literally means under the law. So, for example, one of the things, the threat in question doesn't even have to be communicated verbally according to case law. If someone were to run their finger across their neck, I told you this earlier, in a throat-cutting fashion like this, making some sort of, maybe not even a verbal, but just a body, literally just using body language, using their fingers to make that could be interpreted as an imminent threat. Now, understand that's very open to interpretation, particularly considering the circumstances. So in order to convict someone of assault by threat, the prosecutor must be able to prove that that individual acted intentionally or knowingly. And according to how this has been generally interpreted, this means not only that the person being charged with the crime knew that they were engaging in this behavior, but also that they were aware of the fact that it would be perceived as a genuine threat when they did it. Now, using the example of we used a moment ago about the throat-cutting gesture, right, that's has been brought up before under case law, there are a couple of different defenses right off the bat. For one, the person being charged could easily claim that the gesture was misinterpreted, right? That's not what they meant it for. Perhaps they were just, and I know this sounds goofy, but the reality of it is that the people have done this sort of thing before, and they looked at it and they thought, that guy just threatened me, and he was actually just scratching their neck. Or the defendant, or the person being charged, they knew each other and knew that even though they were upset at them at that time, that they had done that sort of gesture back and forth to each other in the past, and now they were on friendly terms. So you understand that what someone does in the heat of the moment, when people get very upset, when they're angry at each other, they can interpret it one way. But then later on, they can look back on it and say, you know what, that's not fair. That's not what he really meant. He was never going to actually really do that to me. And in that situation, there is something that can be done. If the alleged victim is willing to provide evidence to establish that they were never truly felt that they were threatened in any way, but that they either overreacted or that's just they misperceived it at the time, they can do what's called an affidavit of non-prosecution. And in that affidavit of non-prosecution, they can provide facts, not just say that they don't want to prosecute, but actually provide facts stating, I never was really threatened. I mean, I was upset at the time, but not really threatened. I never felt like I was in an imminent serious bodily injury or death was going to ever take place to me. And information can be provided that could help your criminal defense attorney to be able to help resolve your case, okay? So I want to remind you of this. Whatever you do, don't take the conviction to this type of offense. If you do, if you go in there and you pay that fine, or if you go in and you do a plea before a judge, you could end up having this on your permanent criminal record. One of the most important things you want to be able to do is to be able to get your case expunged. All records related to your case, you want to be able to be expunged and permanently removed from your criminal record so that you can deny that this ever took place. Now, maybe you're facing an assault by contact or an assault by threat charge in the North Texas area. If you are, don't hesitate to contact our law firm at the Hampton Law Firm at 817-877-5200. We would be happy to give you a free case analysis and break down your specific situation and answer all your questions. And I promised you if you waited around to the end of this video, I would also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link below. I'll be happy to send it over to you. And I look forward to seeing you on our next video series. Thanks for joining us today.